Hey Larry, good to see you again.
Hey Jim.
I'm here with Larry Villanueva, the esteemed patent attorney from Gardner Graf. Larry, I know you have tremendous experience. I send clients to you all the time, and certainly I know that you are a partner / shareholder at Gardner Graf. Tell us about your firm, what you do for clients, some areas that you specialize in, and just give us a little background.
Sure. Gardner Graf has been, we started in 1995. We focus mainly and only, for the most part, on intellectual property, which is copyrights, trademarks, patents, licensing associated with intellectual property, and any litigation associated with intellectual property. We focus on all areas of technology, such as electrical, mechanical arts. I'm in the life sciences group, which is chemical and biotechnology, as well as covering all bases in trademarks and copyrights, and like I said, anything regarding the licensing and litigation associated with intellectual property.
Now, if somebody comes to you with a consumer electronics product or a pet product, or it could be anything that's common to people in the consumer products world, can you or somebody at your firm handle that work?
Absolutely. Again, like I said, we have all the technical bases covered. So, an example, you said a pet product, we would have probably one of our mechanical engineers. If someone came up with a new carrying device, that would be, our firm has all the bases covered, and therefore we would have the appropriate person or attorney assigned to that project to help out the client.
Okay. Because when people come to me, there are a lot of misnomers about patents and trademarks, and a lot of people try to do things on their own. I know that there are a lot of software programs available for people to fill out patent applications or to assist them with getting trademarks. I usually discourage that behavior only because I know at the end of the day, if you're going to build a business with your product, and more importantly, you're going to invest tens of thousands, if not hundreds of thousands of dollars into this, and you're going to maybe leave your job and start a whole new career, I always tell people, find a patent attorney. It is so important because it's like building a house. If the foundation isn't intact, the whole thing comes down around you years later. Maybe you've infringed on somebody else's idea. Maybe your patent isn't sound. Somebody knocks off the idea, and now the success you were enjoying is over. Am I correct in thinking
That's
there?
correct. So, and unfortunately, a lot of times it's an upfront cost that a new client or inventor doesn't have, but like you said, it can be the platform or the fundamental base for launching a company or protecting a product. Not only now, but you got to remember, patents have a term of 20 years from filing, so they had 5, 10, 15 years down the road, your product could be carrying a lot of steam and therefore a lot of value, but if there's inadequate patent protection to protect it, then it could be easy to knock off, and therefore the value is diminished of the company, because again, patents are there to prevent others from enter the market and create barriers to entry for competitors, which can ultimately increase and leverage the company or client's value.
Okay. Now, when somebody contacts us and asks us, what's the process like? How long does it take? What are the basic steps, and how long does it take for an inventor to, from the time that they contact you, looking to either trademark and or patent or file a provisional patent or non-provisional patent for that matter? Take us through that.
So I'll do trademarks and patents. So patents first. So usually the process is, client comes to us, we talk briefly, learn more about the invention, learn more about them, make sure we're on the same page, and then we have subsequent follow-up meeting, which then we get into the real nitty-gritty about what the invention is, learn more about it, talk about, timing, when the application needs to be filed, cost associated with that, attorney fees, filing fees. Usually that process, start to finish, takes about 4 to 6 weeks to draft, get the initial information, draft, and file the patent application. Depending on the type of application that's filed, usually on average, applications take from filing 3 years to get to grant and issue, at which time you have an enforceable right against someone for infringement. So usually, and that's what the patent office standard is, and they've got guidelines to try to meet those milestones. For trademark applications, it's a little different, and they're much easier to file. Usually you can get within 6 months to 12 months or a year a registered trademark, and it's a much easier, trademarks are much easier to prepare and file in the form of applications versus patent applications, which are much, much more involved in detail.
Okay, now, if somebody comes to you, has a discussion, is ready to file a patent, there's a lot of questions about, do I file a provisional or